Good morning, class. Welcome to this session. We are starting with the subject of governance. My name is Ankit Sharma. And I'll be taking up this course upon governance. The subject that we're dealing with over here becomes a part of general studies, or what is known as a GS. And within the general studies, it is a part of the main examination. In the main examination of the GS paper, it is divided into 4 categories. You have a GS1, GS2, GS3, GS4. The subject of governance is placed in GS paper number 2. This is the paper that I deal with mostly. Okay. So the subjects that we study under GS are polity, governance, social justice, and international relations. This is the main way in which the GS paper number 2 is divided. Polity, governance, social justice, and international relations. What we are dealing with is governance. Every year in the GS2 paper, you can expect about 4 questions from governance, which is a total of about 50 marks. In fact, I can make a range out of it, 30 to 50 marks. Sometimes the questions are of 10 marks each. Sometimes the questions are of 15 marks, some questions, and 10 marks, some questions. So the average that I'm taking in, if there are 2 questions from 15 mark range and 2 questions from 10 mark range, then you have a total of 50 marks. So this is the target that we are locking for ourselves in terms of understanding how this particular part has to develop clearly. Okay, right? So this is where we are understanding this point about governance. Clear? Now, before I can in a way move forward, let me just introduce to you the topics that have to be covered in governance with us. Okay, a little bit of a outline of the syllabus. The first thing that would be covered over here would be the Representation of People Act 1951. Just give me a cue, class, if you have already covered this part in the polity paper, the RPA. Just let me know. I have to just be a little sure. Have we covered the Representation of People's Act in the subject of polity here? Class, please engage a little bit. Tell me, have we covered the subject of Representation of People Act in the subject of polity? Okay, in any way I can write it over here, you can tell me later. And in this we'll study about qualifications, and disqualifications, and what you can call election petition, the procedure for filing an election petition. Let's say the procedure and content of election petition. The procedure and content of election petition. Okay, thank you, Subrata. Right. I'd like to see you interact a little bit in the class because it is an online medium and I am fairly alone in this room. So keep me in tune with what you are up to there. Okay, so this is the part that we cover. Procedure and content of election petition, in which we'll have the grounds for disqualification of MPs and the powers of the High Court and the Election Commission, etc. Okay, this is the first part that we'll cover. Second thing that we'll cover in governance is the subject of transparency and accountability. Transparency and accountability. In this part, we will cover a few things. For example, first thing that we'll cover here is going to be the conceptual framework to understand the Weberian style of bureaucracy. Right. This is the conceptual framework. Second thing that we can cover over here is what we can call the subject of transparency itself. Subject of transparency includes three ways in which we can divide it. That is Right to Information Act 2005. What is the RTI? Then you have the concept of Citizens Charter, and then associated with that is the concept of e-governance. These are three things that we'll take a look at in transparency, okay, along with understanding the question of transparency. Then we'll take a look at accountability. And within accountability, we'll take a look at certain tools associated with accountability. We have, for example, the CBI, the CVC, the Prevention of Corruption Act, and we can also have a discussion upon the concept of the Lokpal and the Lokayat. This is the third part, which is accountability, which we'll take a look at. Okay. First is conceptual framework. We'll take a look at transparency and we'll take a look at the questions which are coming in the conceptual framework. Then we can take a look at transparency, which is RTI, Citizens Charter, and e-governance. Then we could take a look at accountability, which will include CBI, CVC, Prevention of Corruption Act, and the Lokpal and the Lokayat provisions in the Indian statutes. Then we can take a look at centralization versus decentralization debate. Take a look at this debate, centralization versus decentralization. In this, we'll take a look at centrally sponsored schemes, and we will take a look at central sector schemes. And we will take a look at simultaneous ways. Article 282 of the Constitution. Okay, so these are the three parts we'll cover in centralization versus decentralization. Centrally sponsored schemes, central sector schemes, and Article 282. Clear? Take. Let's just keep our, I'll elaborate the course a little further when I'm at it. Till the time that we are moving ahead, I think this is going to be the first part. We have classes in the next 3 days. We'll try to make sure that we are attaining some understanding of these questions. Okay, just take a look at this chart again. If you have drawn it, if you have not drawn it, please draw it and look at it comprehensively. Just take a minute to understand what I'm giving in this chart properly. Okay, chali, let's start with the first part, which is I'll give you the title of this one. We are basically dealing with the provisions of Representation of People Act 1951. Okay, but the title, the general understanding of this can be basically, you see, I'll just give you a cue as to how you have to prepare for something like this. In the year 2023 and 2022, when I'm talking about it is as an academic year, 2022-2023, there were elections to the post of the President of India. And because there were elections to the post of President of India, there were 2 questions in the prelims examination from presidential elections. 2 questions were asked in the prelims examination from the presidential elections. Okay. Therefore, our simple inference can be that 2024 is going to be an election year for India. 2024 is going to be an election year for India, and therefore, what you are expecting is questions from the Lok Sabha elections. Presidential elections are obviously nothing compared to the Lok Sabha elections, because presidential elections are a mere formality to some extent. But Lok Sabha election is one of the most spectacular representations of Indian democracy. And we will take a look at a lot of questions. We are expecting some questions to come from the Lok Sabha elections in the UPSC, which deal with the concepts of elections, etc., etc. Right? So, let's say, for example, I talk about what are the topics that we can cover in understanding elections. Since RPA is broadly a part of the election chapter, we are going to cover in this part, and I'm sure you must have taken it in the classes of polity also, but I'll just revise it a little bit with you. We can take a look at, for example, Article 84, which talks about qualifications of MPs. Qualifications for becoming MPs, actually. Okay. Then we have Article 101 to 103. This is the articles of the Constitution which talk about disqualification. Okay. And then we have Article 324, which talks about the Election Commission. And then we have Article 325, 326, 327 and 328, which you can say are miscellaneous articles related to elections. Okay. And then we have Article 329, which is about election petitions. Okay, just take a look at these articles as a synopsis. I'll take a quick revision of these articles with you because I want to complete the entire chapter upon election, because it's a very simple deduction that one can make, that in the year of the Lok Sabha elections, if you are appearing for the prelims and the main examination, you will obviously get some questions directly or indirectly associated with elections. So I'm a little careful in telling you that the questions from elections can be a real possibility. So just take down these articles: Article 84, 101 to 103, Article 324, 325, 326, 327, 328 and 329, correspondingly with the materials that have been written over there. If you take a look at RPA 19, I'm sorry, there was a problem with the mic. It's fixed now. When we take a look at the RPA 1951, I'm going to lay out the synopsis of the sections which are associated with the RPA 1951. Okay, I'm just trying to give you a structure of things which can allow you to get a sense of how you can, meaning what I'm trying to do is give you a scope of what we have to read, so that you have a very clear understanding of what all topics are there to be covered in the coming classes, right? You'll have a little bit of a gist or a synopsis in which we can take a look at this. Okay, so section 3 and 4 we talk about qualifications. for MPs. This is RPA. Take a look at section 7 to section 11. We talk about disqualification. For MPs. Okay. Then we take a look at section 80, section 80A, section 98, 99, 100, 101 and 116A. These are the articles associated with election petitions, or what you can say election disputes. There was a question asked in the main examination last year from these provisions. Okay, so these are the sections these are some sections of the RPA 1951 which we'll take a look at in terms of the coverage of the election ideas. Okay, please give me an understanding of this, that I am hoping that the 10th schedule is something that you have covered in polity. If you have not covered the 10th schedule, please let me know now. I will add it to the list of my coverages, because we are specifically going to cover the grounds of disqualification only made by the parliament, which is under RPA 1951. But other grounds of disqualifications which are given in the constitution can be skipped by us. So I'm just asking whether you are on the same tune as this, that the that 10th schedule has been covered. If 10th schedule has not been covered in the constitution yet, I'll make a coverage of it. Please tell me if it is covered or not. Okay. ठीक है, चलिए, you just take a look at this synopsis and then we'll get starting. Okay. Okay, let us begin to start on this. The topic is the topic of elections. Let me just begin with the understanding of what is the Election Commission of India. Okay, we're taking a look at, in fact, sorry, let's not talk with the, let's start with what you can call Article 84 of the Constitution. Article 84 of the Constitution. So 10th schedule is covered, right? Now, if it is covered, then I will not take it again. It will be overlap. If it is not covered, then I could have taken it. Article 84 of the Constitution lies in the subject of Parliament. It talks about the Union Legislature, which is the Parliament. Please now start listening to what I am trying to say. Article 84 of the Constitution lies in the Union Legislature, which is known as the Parliament. And Article 84 talks about the qualifications. for becoming an MP. It gives the qualifications for becoming an MP. What do you understand by the term qualifications? Qualification means that a person is qualified to become an MP. It means that a person is eligible to become a member of parliament. Okay, that there is a kind of an eligibility criteria. If the person meets it, the person can contest elections, right? That's basically what is given in Article 84, which is a part of the parliament. What are the qualifications given in the article itself? There are two qualifications given in the article. One is that the person must be a citizen of India. Whoever is trying to be a member of parliament from the Lok Sabha or the Rajya Sabha has to necessarily be a citizen of India. I'll repeat, whoever is trying to be a member of parliament from the Lok Sabha or Rajya Sabha has to necessarily be a citizen of India. Right? That's the first part. Yeah. Second part, whoever is trying to be a member of parliament from the Lok Sabha has to be a minimum age of 25 years. Whoever is trying to be a member of parliament from Lok Sabha has to have a minimum age of 25 years. Whoever is trying to be a member of Rajya Sabha has to have a minimum age of 30 years. Okay. Let's take a look at this again. Qualifications for becoming an MP. Citizen of India, Lok Sabha minimum age 25 years, Rajya Sabha minimum age 30 years. Okay. The third criteria which has been given over here is that if any additional qualifications are to be made, in what I'm saying is additional qualifications. If any additional qualifications are to be made in addition to A and B, if there are more qualifications which need to be made, they can be made by the parliament by making a law. So parliament can enact a law. Parliament can enact a law to give any additional qualifications. Please pay attention to this. These are two qualifications which are given in the Constitution of India under Article 84. But in addition to this, Article 84 says that if there are going to be any additional qualifications that may be needed according to the time of the requirement, it can be prescribed by the parliament by enacting a law, by enacting a statute. And in this regard, parliament has made what you can call the Representation of People's Act. (1951). Parliament has made the Representation of People's Act 1951, in which additional qualifications have been given by the parliament. So the law gets its power. If we have a question like this, that where does the Representation of People's Act get its power for being enacted? Where does the parliament get the power to create the Representation of People's Act? The answer is the Constitution of India, Article 84, where the Constitution empowers the parliament to enact a law to give certain additional qualifications which are going to be the basis upon which a person can become a member of parliament. Okay. So that is where Representation of People's Act start, and within Representation of People's Act, as we have discussed, there are two sections which are given, Section 3 and Section 4 of the RPA. Section 3 and Section 4 of the RPA, which deal with Section 3 and Section 4 of the RPA, which deal with the, what you can call, the qualifications for becoming MPs, which deal with the qualifications for becoming MPs. Okay. So we'll take a look at these sections independently. I'm sure by this time you are able to cover this, right? I'll just say Article 84 of the Constitution talks about qualifications for becoming an MP. And the two qualifications given in the Constitution are that he must be a citizen of India and he must have a minimum age of 25 years and minimum age of 30 years. By the way, if a question comes like this, that how can these ages in the Constitution, how can these ages in the Constitution be amended? What I'm trying to ask is that how is it possible that you can amend 25 to 45 and 30 to 55? It can only happen through a Constitution Amendment Act under Article 368. The procedure under Article 368 has to be followed if you have to amend the age of a person or minimum age of a person who's contesting elections from the Lok Sabha or the Rajya Sabha, right? Article 368. But if these provisions have to be amended, they can be done by an ordinary law, right? The power of the parliament under Article 46, 246, by an ordinary law, by using a simple or a special majority as prescribed, these points can be amended, right? So it is difficult for the parliament to amend this part because it is given in the Constitution, and to amend this you will require a Constitution Amendment Act. But with regard to this part, it is easy for the parliament to amend it. So because it is an ordinary law, the name of the law is Representation of People's Act. It is a law made by the parliament. So amendments can happen in this regard with these specifications. Okay, so let me just move on and take up the next part, which is section 3 and 4 of the RPA 1951. Section 3 and 4 of the RPA 1951. Okay, both these sections have one simple understanding with it itself. Both these sections state that section 3 and 4, both these sections state that a person can become a member of parliament, from the Lok Sabha or the Rajya Sabha under the condition that he is, let's say for example, if this is a candidate, a person can become a member of parliament from the Lok Sabha and the Rajya Sabha, provided that he is an elector from any constituency in India, right? For the Lok Sabha elections. This is the qualification which has been given in section 3 and 4, that any person who has a voter I card from any constituency in India can be presented as a member of parliament for eligibility for Lok Sabha and Rajya Sabha both. So if you are, let's say for example, contesting elections from Ghaziabad, which is in Uttar Pradesh, but if your voter I card is from Cochin, which is in Kerala, you can contest for elections as an MP from Ghaziabad. Or if you are contesting as a member of parliament from the Rajya Sabha, let's say from the state of Maharashtra, but if your voter I card for the Lok Sabha election is from Banswara in Rajasthan, you can still contest elections as a member of Rajya Sabha from the State Assembly of Maharashtra. You see the point? So any constituency in India, if you are an elector from, you can make yourself a part of the Lok Sabha elections, Lok Sabha and Rajya Sabha elections. You see the point? This is the only thing which has been given over here. Now let me just briefly tell you a background about it. What is the background about it? Very simply stating, in the original RPA 1951, the provision of any constituency of India was only applicable to the Lok Sabha elections. But for the Rajya Sabha elections, the provision of any constituency was not applicable. Okay, let me repeat. The provision of any constituency in India was only for the Lok Sabha elections. For the Rajya Sabha election, the provision of any constituency was not applicable. And the provision which was given for Rajya Sabha is that if I have to get myself elected as a member of parliament from the Rajya Sabha from the state of Maharashtra, I must have my voting card in the state of Maharashtra. That my voter I card must be issued by one constituency in the state of Maharashtra. That was a provision which was given in the RPA 1951. Because the Council of States were supposed to be representatives of the people. You see, of the states. They were supposed to be the representatives of the people of the states or of the state legislative assembly. That's why it's called the Rajya Sabha. So for that, kind of an indication, the RPA 1951 made very exclusive points about stating that the qualifications for a member of Rajya Sabha should be that he should be from that state from which he is being elected to the Rajya Sabha. As you know that the electoral college for Rajya Sabha is made out of the state legislative assembly, and each state is provided certain seats in the Rajya Sabha, right? So this is a part that we are just taking a understanding of. In 2003, the RPA was amended by the parliament. 2003 RPA was amended by the parliament, and this provision was inserted that even for Rajya Sabha, any person can become a member of parliament. Even for Rajya Sabha, any person can become a member of parliament from any constituency in India. The criteria that this person must be from the state of which the Rajya Sabha member is being elected was taken away. Clear? Now, this went to the Supreme Court as a challenge, stating that this kind of amendment violated the federal structure of the Indian Constitution. The Supreme Court took a note of this and the question was that this question violated the federal structure of the Indian Constitution. And the Supreme Court, in the case of Kuldeep Nayyar versus Union of India, 2006, in Kuldeep Nayyar versus Union of India, 2006, the Supreme Court held that this part of the amendment was valid. It refused to strike down the amendment and declared this amendment as valid, thereby upholding this particular part. You see, in Kuldeep Nayyar versus Union of India, 2006. Now, the question is basically that what is the nature of the Rajya Sabha if it is not necessarily representing the interest of the state? Okay. So, the Supreme Court dealt a little bit on that question and made certain observations which I am going to provide to you. Now, the first part of the way which we can answer this question is that the Supreme Court said that Rajya Sabha does not necessarily, represent the interest of the states. Okay, the Supreme Court did this kind of an analysis. He said, like, for example, what is the Rajya Sabha? What is the conceptual basis of, what is the constitutional mandate of creating a Rajya Sabha? Why do we need a Rajya Sabha? These kind of questions the Supreme Court started asking. And one of the ways in which you can think about or answer this question is that, let's say, for example, you have a Rajya Sabha. Let's say, take an example of a person who is very interested in politics and he's attached to a political party, and he has a lot of brains about politics. Let's say, for example, the instance of a person called Prashant Kishore. Okay, Prashant Kishore is a political strategist. He is very closely attached to certain political parties, and he is, in a way, involved in certain actions by which political parties organize their political campaigns, etc., etc. Now, people like Prashant Kishore are very good at understanding politics, at organizing political events, as strategizing political activities. But they may not be people who can become politicians themselves. Prashant Kishore may be excellent strategist in terms of elections, but if he starts contesting elections by himself, he may not be winning it. Right? He may not be the one to win the elections. He may not be able to win the elections because the people may not give him, that kind of vote, etc. Okay. So the question is, if people like Prashant Kishore are instrumental in creating the power structure for the political parties, and let's say Prashant Kishore helps someone become the member of parliament from a particular constituency, why would Prashant Kishore do it? And the answer is that the Prashant Kishore will not do it only for the reward he's getting in terms of money, etc. But he also wants to become an instrumental figure in terms of becoming a union minister, or becoming a member of parliament, or becoming a, this kind of a situation where, this event has to be taken in a way in which he will get some power. After all, a person will work for something like this for power. Okay. Now, let's say, for example, if one political party is highly indebted to Prashant Kishore for having organized their elections properly, what that political party will do is, they will take Prashant Kishore and introduce him before a legislative assembly of a state in which they have a majority power. Let's say, for example, you have the Bharatiya Janata Party, who's working closely with Prashant Kishore. Prashant Kishore has got them to win the Lok Sabha elections. Now what will happen is, Bharatiya Janata Party will take Prashant Kishore and present him before the State Assembly of Gujarat. And from the State Assembly of Gujarat, Prashant Kishore can be launched into the Rajya Sabha, become a member of Rajya Sabha. Right? And once he is able to become a member of parliament, he has now himself directly involved himself into creating structures of power. Right? In a way, he started becoming directly involved with how power works. He will have a say in how laws are made. He can have debates in the parliament. He can raise his voice in the issues of national concerns, etc., etc. You see the point? So the question is about the ability of Prashant Kishore to convince the political party that he should be made an MP. Right? But he cannot contest the Lok Sabha elections directly. So one thing that we kind of, let's say, for example, you take an example of Dr. S. Jaishankar, who is the foreign minister of India. Now, he wanted to, he was working closely with the political party. He was a foreign secretary. He was instrumental in designing a lot of, policies for India in the first tenure of the Modi government. But at the same time, he could not become a foreign minister because he was not a member of parliament. So what the BJP did was, they took S. Jaishankar to a state in which they had a clear majority, and from one of the seats allotted to that state, he could be launched into the Rajya Sabha, made a member of parliament, and then be allowed to become a minister. You see the point? So what the court said eventually is this, that the way that political parties generally look at Rajya Sabha is not that it is a representative of the states, but that it is a kind of a method of conducting elections by which member of parliaments can be elected. It's just a way of, for example, let's draw an analogy to this. If, let's say, for example, you're reading for the UPSC examination, okay? Now, one way of thinking about UPSC syllabus is that you're supposed to learn everything which is given in the syllabus, feel the subjects, understand it, get a mastery over them, command them, internalize them so that you can, get a better understanding of these things properly, right? And you can use them in your everyday life. This is one understanding. Second understanding is that, see, UPSC needs people who can become IAS officers, right? And there is no other method of doing it but by conducting an exam. And however broken the system of exam, or however underdeveloped, or however whatever, at least there is a kind of a reasonable way in which we can say that exams conduct करा के हमने लोगों को अंदर लिया है. You see the point? So rather than saying that we are doing kind of an exercise of self-realization while we're reading for the UPSC, people think that it's just a method of getting into the IAS offices. You get the point? And so that kind of a enchantment or idealism with the UPSC syllabus can be toned down a little bit from this perspective. And that is exactly what the Supreme Court said. Supreme Court said that take a look at the members of Rajya Sabha. Some of them will not even remember from which state they have been elected. Because obviously, if you have a member of Lok Sabha, he is attached to his constituency. He works for his constituency. You have the MP, fund and everything which he can take care of in the constituency. But if you look at a member of parliament from the Rajya Sabha, he has nothing that he can do for the state from which he comes out of, except for the fact that he has just been, exposed to a method of processing. Since you have to have a parliament which is elected, you have to find a way that elections can happen, and one of the more convenient ways of getting those elections done is by the Rajya Sabha, by the state legislative assemblies. So the Supreme Court in a way understood and clearly accepted this logic by the government that Rajya Sabha does not necessarily represent the interests of the states. What Rajya Sabha or what states' connections to Rajya Sabha is, that it's just a method of doing elections, so that the member of parliament in the Rajya Sabha who cannot, let's say, or choose not to fight dirty politics in terms of the Lok Sabha elections, choose to remain behind the scenes, but nonetheless they are instrumental in the political party's success, and they also want to involve themselves into a law-making process. They also want to become ministers. And that is why, obviously, you understand that Rajya Sabha has been given a little bit of an inferior power to the Lok Sabha. You've seen in the money bill, in the joint sitting, in cases of, all things which are Rajya Sabha based, you very clearly understand that the powers to the Rajya Sabha are significantly under the control of the Lok Sabha, especially with regard to the money bill. You see the point? So this kind of a thing is very clearly understood by us in making an understanding of this question as to why Rajya Sabha does not, in actual terms, represent the interests of the states from which it is formed, but it is just a way of doing elections. And on the basis of this logic, Supreme Court said that any person holding a voter ID card from any constituency in India can be contesting the Rajya Sabha elections also, and declared the amendment made to the law as valid. Okay. If a candidate wants to fight an election in another constituency outside his own constituency, where will he give his own vote? Of course, he will cast his own vote in his constituency, and he will get elected from another constituency from where he is standing. That's just technically correct. Why is education not a qualification fixed for an MP? Because MPs are supposed to be representative of the people. If the people are uneducated and they feel that an uneducated person can understand their problems, then he is supposed to take the problems of the uneducated people and present it before the government or present it before the parliament. You see the point? He is not a leader of people, he is a representative of people. He reflects the masses of India. He is the, what you can call, a person who is in a way carrying the will of the people of India. He is not supposed to be a leader or a self-enlightened person. He is just supposed to reflect what India looks like. Why Rajya Sabha has more power in the creation of All India services? Because the people of the Rajya Sabha are considered to be the ones who have the better understanding of certain sophisticated matters regarding public administration. For example, you look at the membership of Rajya Sabha, these people have some amount of, even the 12 nominated members given by the president and other members of the Rajya Sabha are supposed to be people who have a deep thinking understanding of politics. They may not be politicians, but they understand politics, and the action of creating a new All India Services is an immense activity. It is not for the safeguarding the state's interest that they can only be created by the Rajya Sabha, but because of the nature of the Rajya Sabha as being the elder and the wiser house, they have a better understanding of how the public administration works. You see, a person like Hardeep Singh Puri would understand the IFS better than a person who's sitting in the Lok Sabha. And Hardeep Singh Puri is a minister. He is a retired IFS officer himself. So the populace of Rajya Sabha is composed of what you can call intellectuals and people who have an understanding of matters in a little bit of a scholarly terms, and that is why the power of All India Services was given to the Rajya Sabha. Yeah, you can use Nayan. It is absolutely correct. You can use section 3 and 4 in answering about India as one nation. Correct. A president can only nominate 12 members, right? There are many members in the Rajya Sabha and only 12 can be nominated by the president. So what happens to the rest of them, right? It's very simple. You like a person who has helped you. Take an example of Arun Jaitley, who was the finance minister of India in the last 5 years of the first 5 years of the BJP government. The Arun Jaitley was an excellent political campaigner for BJP, but he lost Lok Sabha elections from Patiala, right? But he wanted to be in power. So what BJP did was, BJP took Arun Jaitley to the state of, let's say, Madhya Pradesh, where there is a large population of MPs from BJP in the state assembly, and from there he was elected as a member of Rajya Sabha. But then he doesn't have anything to do with Madhya Pradesh. It's just a means to an end, and then he became the finance minister. Okay. Okay, let's go forward. Right, so this is the point about the qualifications and the Kuldeep Nayyar case, and a little bit of an understanding about how the Rajya Sabha works in totality. Okay, now we come to the next part, which is disqualifications. Subrata, when the persons who are contesting for election are uneducated, how can we choose an educated MP? But then who says that the MPs have to be correct? They have to represent India. Sir, what we mean to say is that if India is uneducated, you have to deal with India as uneducated. You can't change the fact unless you change the fact that they are educated people. The point is not about ideas, the point is about reality. If we have a lot of uneducated people, we will have uneducated politics, and that's the way Constitution wants it to be, right? Because it has to be really the spirit of India. And also, by the way, education as a virtue is overestimated. Okay, there are people who may not be literate, they will not be educated, but they have better wisdom in a lot of things than the persons who are so-called educated, etc., etc. So 2 points to counter what you're saying. Number one, we have to represent India as it is. Even if it is making a mistake, let it make a full mistake so that it can learn from itself. And second, things like education cannot necessarily be absolute virtues. People who have missed out on education, it is not necessary that they are also not very clear and wise about what they are trying to do. And I'm sure you will have experiences and examples from your own circumstances where you'll find someone who's not educated but is smart enough, smarter than us perhaps. So RPA can add additional qualifications. Why has it not stopped the criminalization of politics? We are going to take a look at disqualifications. If a member of parliament is found to be doing something of a criminal nature, he can be disqualified from being a member of parliament. All that criminalization part is covered in disqualification. Okay. Right. Disqualifications. So let's take a look at the provisions given in the Constitution. Okay. You have Article 101, which talks about, please take a look at this nicely, okay? If you've done this already, you will be able to revise. If you've not done it, please pay attention to this. This is all that covers under the category of disqualification. Article 101 talks about vacancy of MPs, or what are the ways in which a seat of a member of parliament can be rendered vacant. Okay, vacant is just different from disqualification. The relationship between vacant is this Venn diagram that I'm drawing over here. Okay, you have this as vacancy. Okay, now vacancy can be of many kinds. For example, one of the ways of vacancy is resignation. Another way of vacancy is disqualification. Another way of vacancy is he is simultaneously a member of parliament from the Lok Sabha and Rajya Sabha. You see, so what we see as disqualification is, think about it as a syllogism. All A is B, which means all disqualifications are vacancies. All disqualifications lead to vacancies, but not all vacancies are done by disqualifications. You can also have vacancies because of resignation, or because of a simultaneous membership, or because of death of an MP. Okay, so the relationship between vacancy and disqualification is that of all A is B. So all disqualifications are vacancies. Not all vacancies are disqualifications, but some vacancies are disqualifications. Okay, so what we understand is that article, just to give a structure of it clearly, article 101 talks about vacancy and article 102 talks about disqualification. Okay, let me repeat it again. Article 101 talks about vacancy and article 102 talks about disqualification. So this kind of a subset and a superset way that you can understand this part. Okay, so article 101 talks about vacancy and it lays down what you can call four ways in which a seat can be rendered vacant. Four ways in which a seat can be rendered vacant. Okay, first way is that a member of Lok Sabha and member of Rajya Sabha. If a person is a member of Lok Sabha and Rajya Sabha simultaneously, at the same time he is also a member of the Lok Sabha and he is also a member of the Rajya Sabha, he can be asked to vacate his seat, or his seat from one of the houses will automatically be vacated. Okay, look at this. Why do you have a provision like this? Let's try to understand the logic and rationale of it. If you have, let's say for example, think about a situation like this. Let's say if a political party, let's say if this is a political party, PPP, this is a political party. Okay, if a political party has 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 star candidates. If a political party has 10 star candidates, 10 star candidates meaning these are the people who have a very popular appeal in the masses. Meaning about these candidates, it is said that, let's say for example, this candidate, you field him wherever for an election, you field him for a member of parliament election, you field him for a member of legislative election, you field him for a municipality election, he will win every election because everyone in India knows him. He is a very popular figure. You see the point? So if a political party has 20 such popular figures, what the political party can do is that, let's say for example, this political party is making a kind of a strategy for the next elections. Let's say this is the Lok Sabha, right, and this is the Rajya Sabha, and this is the Vidhan Sabha. Let's say Vidhan Sabha of, let's say, Maharashtra. This is the Lok Sabha, Rajya Sabha, Vidhan Sabha of Maharashtra. Okay. Now what this political party can do is, let's say they are targeting 20 seats in Lok Sabha. Okay, they're targeting 20 seats in Rajya Sabha, and they're targeting, let's say, 70 seats in the Maharashtra Legislative Assembly. This is what these parties are. This is what these, what you can call, this political party PPP is targeting for the next elections. Now, what this political party can do is, since this person is a star candidate, okay, what they can start doing is, they can field him for the Lok Sabha elections and get 1 out of 20. Since he's a very popular figure, he will win the Lok Sabha elections. They can field him in the Rajya Sabha election and get 1 out of 20, and they can field him in the Maharashtra Legislative Assembly elections and they can get 1 out of 70. Just think about this as a possibility. For just 1 second, pause and try to think of this as a possibility. Is it not going to happen? What it will lead to is that one particular popular leader is getting this political party an ability to attain a control over 3 houses at once. You see the point? 3 houses at once can be controlled by this political party in the absence, because of this particular person. You see the point? Now, what does it lead to? It leads to nepotism. It leads to a kind of an oligarchy. What is an oligarchy? Oligarchy is a government by the few. Now, the political party can start investing all of its firepower only in the politicians which belong from their family, and not let anyone else come in the surface to become the face of the political party. And these people are invested so much about that they become popular in the entire country and they can win elections. So, if you have, let's say, for example, a political party which is composed of 600 people and all 600 of them are very popular, then all 600 of them can occupy all the houses in the country. And because they are occupying the Lok Sabha, Rajya Sabha and Vidhan Sabha at the same time, they will be able to control the Indian democracy from the top very clearly, and which will become an oligarchy, which will suppress the rise of new politicians, new leaders, etc., etc. Therefore, a very clear rule has been made in the first ground of vacancy under Article 101, that if you are simultaneously a member of Lok Sabha and Rajya Sabha, you have to render your seat as vacant. If you are simultaneously a member of the Lok Sabha and the Rajya Sabha, you will have to vacate your seat. It is very clearly given in Article 101 as the first condition of vacancy. Clear? Second, if you are simultaneously a member of Union Parliament and any state legislature. Okay, if you are simultaneously a member of Union Parliament and any state legislature, your seat will be rendered vacant after, but any of the seats, either you have to vacate this or you have to vacate this. You see the point? So, this is the two conditions under which your seats can be rendered vacant. If you are simultaneously a member of Lok Sabha and Rajya Sabha, and if you are simultaneously a member of the parliament and the state legislature. And I hope you understand the reason for it. The reason for it is that it is a prevention of India from converting into an oligarchy. Students of political science would understand oligarchy is a form of government in which the control is given to a few people, right? So, that's basically the point about this. Then the third condition, a third, what you can say, ground for vacancy is that of disqualification. That if a member of parliament has been disqualified under the provisions of Article 102. Okay, please try to direct this to this part. Think of this like this. Disqualification, which is basically about Article 102. If a member of parliament is disqualified under Article 102, then his seat can be rendered vacant. So it is over here that we will expand our understanding of disqualification. So we will reopen this part when we reach to Article 102, which deals specifically with disqualification. And point number 4 is resignation. I'll explain this a little bit now. Resignation. Just take a look at this. These are the 4 points in which, or these are the 4 ways in which a member of parliament has to render his seat vacant. These are the 4 ways in which a member of parliament has to render his seat vacant. One is Lok Sabha and Rajya Sabha. Second is parliament and state legislature, simultaneous membership of the two. Third is disqualifications under Article 102. And fourth is resignation. Clear? These are points that we are trying to understand. Clear? Let's elaborate a little bit upon resignation. Now, resignation says here, the Constitution says that a member of parliament can resign from a house, but it is provided that the seat of the member of parliament cannot be rendered vacant unless the resignation is accepted by the speaker. Or chairman. A member of parliament can resign, but his resignation will come into effect only if the speaker or the chairman accept his resignation. And if the speaker or the chairman feel that the resignation has been given without it being voluntary, if a resignation has been given without it being voluntary or under some kind of a political pressure, which has questioned its genuineness, then the speaker of the parliament the speaker of the Lok Sabha and the chairman of the Rajya Sabha can reject the resignation of the member of parliament. You see the point? This was not in the original constitution, this part about speaker having the power, the ability to accept the resignation, but it was brought to the constitution as an amendment. Okay. Now, in this part, it was very clearly stated that, this is a kind of a thing which tells you very similar to the 10th schedule. So for example, member of parliaments in India do not have that kind of a power in the parliament. It is the political party which holds the power. Not member of parliaments have the power, but the political party which holds the power. We have seen that in a paragraph 2 of 10th schedule that you have, for example, if a member of parliament doesn't align with the political party, doesn't align with the voting position of the political party, then the political party can proceed to get the member disqualified for defection under paragraph 2 of the 10th schedule. So, independent member of parliaments cannot necessarily go against the position of the political party. At the same time, you have the possibility of stating that if, let's say, a bunch of member of parliament want to resign from the Lok Sabha, let's say 20 member of parliament, if they want to resign from the Lok Sabha, the resignation of 20 members does not only mean that they will not be members of Lok Sabha, but it also means that the political party will lose 20 seats in the Lok Sabha. which will in a way diminish their majority in the Lok Sabha, which can also translate into them having to face the vote of confidence in the Lok Sabha. You see the point? Therefore, this amendment made to the constitution allows, in a way, enables the speaker, who is obviously from the ruling party and who's more or less hand in glove with the ruling party. It allows the speaker to carry out an inquiry whether the resignation was voluntary or genuine. And based upon his inquiry, the speaker can strike the decision upon the resignation and say that I am not accepting the resignation because it was not genuine or because it was not voluntary, and keep the member of parliament from leaving the parliament by resignation. Now, this is what is given in the constitution as a provision, but if you understand the politics behind it, of course the speaker is not going to accept the resignation, because speaker is taking instructions from the political party, and the political party will not want the seats in its house to be lost. You see the point? And therefore, this kind of a situation does lead to giving the powers to the political party in terms of getting the seats and the getting the majority under its control in terms of the way in which it is working for the control of a particular house very clearly, right? Political party over and above the member of parliament. This is part is given in the article 101 as the last part about resignation. Okay, cool. Okay, so I'm just in a way putting it again before you. Article 101 talks about vacancy of MPs. There are 4 ways in which a seat can be left vacant: simultaneously member of Rajya Sabha, Lok Sabha, simultaneously member of parliament and state legislature, disqualification under article 102, which we'll take a look at after this, and resignation, which is given with a caveat, which is given with a kind of a understanding that unless the resignation is accepted by the speaker chairman with being voluntary, political pressure not genuine. Okay, clear? Take care. Now we talk about what you can call article 102, in which we deal with disqualification. Please remember, article 102 comes out of the third point of article 101, which is one kind of a vacancy is by disqualification. One way in which a seat can be rendered vacant is by disqualification. One of the ways in which a seat can be rendered vacant is by disqualification. Okay. Okay, Nimai has a question. In case of disqualification, the decision of Speaker of Lok Sabha is final. Sometimes decision is biased in nature. Here a question arises with the post of Speaker. Why? Question mark, question mark, question mark, question mark. And please discuss the concept of once a Speaker is always a Speaker. Please wait until, okay, by the way, this is a part of disqualification under anti-defection. Okay, what you're saying is disqualification with relation to anti-defection only. 10th schedule, paragraph 7 gives the power to the speaker to disqualify someone if that person is found to be of violation of anti-defection law. Other than that, the speaker does not have power to disqualify. The power to disqualify is with the President of India in consultation with the Election Commission of India under Article 103. That is one way I can give you your answer, that you have an understanding. The speaker can only disqualify in matters of 10th schedule, but even the decisions of speaker in disqualification can be subjected to judicial review under the Kihotu Holohon case. Is 1992 judgment by the Supreme Court. The Supreme Court has said that a decision of the speaker can be corrected by the state, corrected by the Supreme Court. It falls under the purview of the judicial review. Okay. Supreme Court verdict about the Shiv Sena Maharashtra case is a part of the anti-defection law, which I feel that you've covered. So I will have to skip that because that part is already taken up in polity. Let's take a look at the next part. Article 102, we'll try to understand this. Article 102 talks about disqualifications. Okay, Article 102 talks about disqualifications, and within disqualifications, we are taking a look at, let's say for example, first point is about grounds for disqualification. That what are the ways in which a member of parliament can be disqualified. And here we can take a look at 6 grounds. In fact, right? Just write it over here. 6 grounds. There are 4 grounds for vacancy. One of them is disqualifications. And then from there are 6 grounds for disqualifications, which are listed here under. Okay, what are the 6 grounds for disqualification? A, you have, for example, which are the questions which are related to office of profit. That if a member of parliament has an office of profit, he will be disqualified. Then there are questions related to what you can call unsound mind. If a member of parliament has unsound mind as certified by a competent court, unsound mind as certified by a competent court, he can be disqualified. Point number C, a person can be disqualified if he is an undischarged insolvent. A person can be disqualified if he is an undischarged insolvent. C. Okay. Point number D, a person can be disqualified if he is not a citizen of India or he has left the citizenship of India. If he is not, or he has given up the citizenship of India, and if he is not a citizenship of India or has given up the citizenship of India, and he has what you can call taken the adherence or allegiance of a foreign state. For example, Vijay Mallya, who was a member of parliament from Rajya Sabha, but because he was a fugitive, he is a fugitive, it can be said that he was taken out of the Rajya Sabha because he went to London and he had taken an adherence and allegiance of a foreign state. What it means is that he was working under the protection, or he was being protected from prosecution by the refuge that was given to him by a foreign state. Clear? This is 4 grounds. Then you have the 5th ground attached to it, which is by a law made by the parliament. This is where it comes out as. Additional disqualifications. What are those? By a law made by parliament. by law made by Parliament. And then there is F. That is anti-defection law, 10th schedule. Tenth schedule, anti-defection law. Okay. So this is where we have 6 points under which a person can be disqualified. And within this 6 point, we are going to take up this 5th point, in which we will discuss additional disqualifications made by the Parliament under RPA 1951, which is from section 7 to section 11. Please take a look at this. These are the 6 grounds upon which a person can be disqualified. We are only interested at this point on point E, which is additional disqualifications by law made by Parliament, under which the RPA 1951 has been made, and we will take a look at section 7 to section 11 with this regard. Clear? Now, the question that Om is asking, Speaker or Chairman may be biased to a political party, so why will they accept the resignation to be voluntary or genuine? Of course they won't. I'm telling you, it's clear. Political party will hold an MP from resigning, because in India, political party is superior to an MP. Just ask yourself the question, how many MPs win elections because of their own popularity versus how many MPs win elections because of the party which has given them ticket to fight elections? You see the point? And you'll have an answer to that. Most of the elections which are won by MPs in India are not because of their own popularity among the people, but because they are ascribed authority and power by a political party. Right? They are using the brand of the political party, and therefore, until this kind of an activity changes, political party will have a control over how the MPs are going to function. They cannot move away from the power of the political party. That's a good question. Shiladitya, that's a very good question. No. All the questions, this is what Article 329 states, that any law which has Article 328 and Article 329 read together state that any law which is regarding elections can only be made by the Parliament, whether it is for the State Assembly or for the Lok Sabha and the Rajya Sabha, the President and Vice President. Okay. In case the Lok Sabha, the Parliament, deliberately leaves one part out from making laws on, then the state can take it up. Okay. So states can make laws with regard to any of these things, disqualification, etc., or any about elections, only when that area has been deliberately left away by the Parliament for the states to make a law upon. So it's on charity that states can make a law upon this. Otherwise, the states cannot make a law upon this. This is given in Article 327 and Article 328. Okay, that's a good question. So RPA not only governs the State Assembly election, Lok Sabha or Rajya Sabha, but also the State Assembly elections. It's a consolidated law which has been made by the Parliament. But that's a very good question. Okay. So we are taking a look at RPA 1951. RPA 1951. And this part is a little slightly elaborate than the part about qualifications. And to those who are asking about the criminalization of politics, etc., it will all come over here. Okay. Section 7 to Section 11 of the Representation of People Act talk about the disqualification of member of parliament. Please remember that if any of the things which are mentioned in orange have to be amended, they can only be amended by Article 368. If a provision under orange has to be taken out, then it can only be amended by Article 368. But if a provision under white is to be amended, it can be amended by an ordinary law. So, the special provisions given under Article 368 are not needed to amend the sections of the RPA, right? So, some fixed provisions have been given by the Constitution with regard to amendments, and then there are some variable positions which can be varied by the Parliament from time to time, right? I want you to keep this in mind very clearly. Okay, disqualification. Let's take a look at this. We are taking a look at the sections, and I am insisting, please be sure about that, in which you can take a look of as winning the memorization of article number and section number is not completely useless for the UPSC examination. We have seen in the prelims examination this year that certain articles by their very numbers have been asked as questions. Okay, so to think that the memorization of article numbers is not going to be of any help is a misnomer. You have to be ability to at least at least of some selected articles you have to remember the number of article, but the number at which that article is. For example, 335 was asked in the prelims examination this year, and that is also true for the sections of the RPA, which is something that you can remember. It will help you out in answering questions. Okay, so we're dealing with the first section, which is section 7. Okay, section 7 of the RPA, it defines disqualification. I hope that you're taking running notes out of what I'm drawing on the board. Section 7 of the RPA defines disqualification. Okay, what does it mean? What does a question about definition of disqualification mean in this sense? It means that disqualification will have two aspects to it. Disqualification will have two aspects to it. One is that a person who is currently occupying the position of an MP will be asked to get out. Let's say I am a person who is an MP, I am sitting on a seat. Let's say if I am discovered to be of an unsound mind, I will then be asked to leave my seat. That's one aspect of disqualification, right? The other aspect of disqualification is that I can be prohibited from contesting future elections also. That let's say after 4 years again elections happen and I am a very popular leader still, but I am a criminal. Despite my popularity, I will not be allowed to contest elections, because disqualification means not only that you will be asked to leave from your current position, but also you will be prohibited for contesting future elections. For a specified time period. Prohibited from contesting future elections for a specified time period. Okay, this is how you can think about disqualifications, that you can have a thing which you can do in the current elections also, but also prohibited from contesting future elections for a specified time period. This is what section 7 says covers disqualification, right? So please remember this definition of disqualification, that the current period, but over and above you can be asked. Let's say for example, if a person has been disqualified for a period of 8 years, 8 years means that he will have to vacate the seat of the parliament immediately, and he cannot contest elections for the next 8 years, right? But if he is contesting elections at the expiry of 8 years, he is reinstated. So the specific periods, specified time periods are given in different provisions as to how long the person has been disqualified. This is what section 7 of the RPA states, that a person can be disqualified on these grounds. Clear? ठीक. Now that we've understood section 7, let's take a look at section 8. Now section 8 is the most important section with regard to disqualification. I want to, in a way, reflect to the language of the RPA Act itself. When we talk about section 8 subsection 1, in fact section 8 is divided into 4 subsections, right? You have section 8 subsection 1, section 8 subsection 2, section 8 subsection 3, and section 8 subsection 4. Okay, this is how you have divided section 8 into different subcategories. Section 8 subsection 1, subsection 2, subsection 3, and subsection 4. Clear? Okay. So I'm just going to elaborate upon section 8 subsection 1, and in fact I can do section 8 subsection 2. These are both specific offences section 8 subsection 1 and 2 are both specific offences under which an MP / MLA can be disqualified. Section 8 subsection 1 and 2 are specific offences under which an MP / MLA can be disqualified. Okay. So for example, let's say section numbers of certain offences have been mentioned over here, that if a person is convicted of, that person can be disqualified. Okay. So let's say for example, if an MP is convicted of, if an MP is convicted of, let's say for example, A, Prevention of Civil Rights Act 2005, which deals with the crime or offense of untouchability. So if a person is convicted of, if a judge has given an order of conviction against a person who has been involved in untouchability, if a judge has given an order of conviction for a person who has been involved in untouchability, then that person can be declared to have been disqualified. You see, let's say for example, another, let's say if a person has been punished under section 498A of IPC, which deals with cruelty towards a woman, under by a husband or the relative of a husband, then this person who has been convicted for the offense of section 498A can be disqualified. Okay. Then let's say for example, C, any person who's involved under the offences of narcotics and Psychotropic Substances Act, which is basically anyone is consuming drugs or is involved in the trafficking of drugs under the Narcotics and Psychotropic Substances Act. If he is convicted of having committed an offence under this act, he will be disqualified and remain disqualified. Let's say if anyone disturbs or incites communal hatred, if any person disturbs or incites communal hatred between two communities by doing some kind of activity or hate speech, etc., that person, if he is convicted of that offence, can be disqualified, right? So section 8 subsection 1 and section 8 subsection 2 deal with many sections, many what you can say points which can be used as the if a person has been convicted of any of these offences, and there are many of them, I'm just giving you example of four: untouchability, cruelty towards women, consuming narcotics and psychotropic substances, or disturbing or inciting communal hatred. These are examples. If a person has been convicted under these offences, that person can be disqualified. So let's say, for example, what the parliament can do is, parliament can take any crime, let's say the crime of injuring someone, and the section of that crime from that law can be taken by the parliament and inserted under section 8 subsection 1 or 2. And when it is inserted in section 8 subsection 1 or 2, if a person is convicted of the crime of injuring someone in his body, that person can be declared to be disqualified as a member of parliament the moment his conviction order is released by the court. You see the point? The moment the conviction order is released by the court, that person can be disqualified under section 8 of the RPA 1951, section 8 subsection 1 and 2. So parliament can either remove these sections out from RPA or introduce new sections into the RPA section 8. And this is how the parliament can, the question that you were asking was, how do we regulate, how does the parliament regulate the criminalization of politics? The parliament can move these sections into the RPA or move these sections out of the RPA, and this is how it can regulate the activities of criminalization of politics. Clear? Right? Yeah, I'm going to discuss the Rahul Gandhi case in detail. Hopefully today itself, in the next session, we'll take a little bit of a detailed understanding of the Rahul Gandhi case. So be prepared for that also. Okay, right. So you have this part, which is section 8 subsection 1 and section 8 subsection 2. Now we come to section 8 subsection 3. That is the important part, right? If I'm taking about section 8 subsection 3, section 8 subsection 3 is a generic section. Please be mindful that with regard to section 8 subsection 2, we had given what you can call specific laws. If a person is convicted for having done those offences, that person will be disqualified. Section 8 subsection 3 gives a generic understanding. What is a generic understanding? It says that if any person is convicted of any offence for which the imprisonment in fact, just let me rephrase it. If any person is convicted for an offence for any offense and has been imprisoned for a minimum of 2 years so let me just rephrase it more technically, has been sentenced to serve and imprisonment of minimum 2 years, he will be disqualified. Take a look at this sentence now, it structures properly. It says that if any person is convicted for any offense and has been sentenced to serve an imprisonment of minimum 2 years. So any offense, if a person has committed any offense and under that order of conviction, that person has been imprisoned for serving a jail term of 2 years, then he will be disqualified. Then he will be disqualified for a period of 6 years. Then he will be disqualified for a period of 6 years. Then he will be disqualified for a period of 6 years from the date of his release. From the date of his release. Okay, 6 years, please make sure you understand it correctly. From the date of his release. At least write this down properly so I can explain to you. This is exactly the section that applied to Rahul Gandhi in his case of having been disqualified as a member of parliament. Please take a look at this clearly. If any person is convicted for any offense and has been sentenced to serve an imprisonment of minimum 2 years, then he will be disqualified for a period of 6 years from the date of his release. That's the instrumental part. From the date of his release. Okay, 6 years, not from the date of the conviction or sentence, but from the date of his release. Clear? Okay. Now, just before after exactly this, I'll take up the Rahul Gandhi case completely. 8 subsection 3 mein. But before that, let me just introduce section 8 subsection 4 also, and what are the ways in which this section has undergone developments. Section 8 subsection 4 says that any disqualification Section 8 subsection 4 states that any disqualification made under section 8 can be cancelled if a person who is convicted and disqualified, files an appeal against the order of conviction, to a higher court, comma, within 3 months of conviction. Now, this was a provision given in the original RPA under section 8 subsection 4. What did this provision say? That if any person is disqualified under section 8, that disqualification can be cancelled. Matlab that person can restore his membership in the as a member of parliament or MLA if that person who is convicted and disqualified files an appeal against the order of conviction to a higher court within 3 months from conviction. You see the point? This is the kind of interesting part about it. That if a person can file an appeal, just filing an appeal is enough. Let's say if I am convicted under a in law, let's say for example, if I am convicted as for untouchability, and the court has punished me for untouchability. If I have committed untouchability, immediately I will be disqualified from the Lok Sabha. But if I go and challenge the order of the court before a high court or a Supreme Court in a kind of an appeal format, even if that appeal is not dismissed or disposed, even if that appeal has not been decided upon, in the duration of the time of the appeal, I will be restored my member of parliamentship. And that's of course absurd, because in India you can get your appeals to stretch for as many time as you want. You can get the matter to be postponed and postponed and postponed, right? The fact that you can file an appeal and never get that appeal to hear is basically something which we are taking a look at very relevantly in the Indian judicial system. And therefore you can have 4 years of appeal and 5 years of appeal which are not being heard. And by the use, or what you can say, abuse of this section under 8(4), the member of parliaments can commit offences, can be convicted by courts, and can file appeals, and then get the appeals to be postponed for indefinite amount of times. And therefore that kind of a thing can lead to a problem in terms of meeting the spirit of the RPA 1951. You see? And that is why a public interest activist from Kerala by the name of Lily Thomas had filed a petition before the Supreme Court of India in 2013, in which the Supreme Court of India struck down the section 8 subsection 4 as unconstitutional, stating that the parliament cannot make a law like this because it is ultra vires the power of parliament. It is not within the authority or the power of the parliament to make a law like this. Ultra vires the power of parliament. You see the point? So the Supreme Court of India in Lily Thomas versus Union of India had declared section 8 subsection 4 as unconstitutional, stating that it is ultra vires the part of the parliament. The parliament cannot make a law like this because it in a way infringes the spirit of Representation of People's Act. It does not sit well with the spirit of what is given or what the objective is of the RPA. So of course, you see, this is exactly the argument that was made, that in Indian judicial system you can have appeals endlessly. You can go from one court to another court and then get the appeal fixed over there without getting solved. And in the meantime you can be a criminal and at the same time retain your membership of parliament, even if a court has ordered that, or court has decided or ascertained that the order of conviction is right and based upon evidence, right? So in this sense what you are seeing is a very clear judgment given by the Supreme Court under section 8 subsection 4, right? So I'm just going to revise this part again a little bit with you, and in the next session, as we are resuming it after the break, I will discuss the story of the member of parliament from Wayanad, Kerala, and see how the disqualification was effectuated. We are going to deal with this section itself. Section 8, subsection 3 and 4 of the RPA 1951, and along with this we will also take section 499 and section 500 of the IPC, which deals with the concept of criminal defamation. We will take up these sections. Section 8 subsection 3 and 4, section 499 and 500 of IPC, which deal with the concept of criminal defamation in terms of understanding the current updates about the disqualification of a member of parliament from Wayanad constituency in Kerala. Right? Just take a quick revision of what we have covered till now. Okay, I'm structuring everything very categorically for you. In the GS paper number 2, you have governance. Governance has 4 questions into it, and the 4 questions here are about 30 to 50 marks which are given. And you see, for example, you have in governance syllabus deals with the RPA 1951, which we're dealing with qualifications, disqualifications, and the procedure and content of election petition. And then I started with the whole ideas of elections properly. Article 84, we have dealt with qualifications, 2 qualifications given in the constitution, remaining given by the RPA 1951, section 3 and 4, Kuldeep Nayyar versus Union of India, we have discussed. What we are dealing with is article 101 to 103. Out of this, we've taken a look at article 101 and article 102. And from 102, we've taken the 5th point and opened up into the RPA 1951, section 7 to section 11. Okay. So section 3 to section 4 we have covered. Section 7 to section 11 we are currently covering. We are at section 7 and section 8. Right. Section 7 defines disqualification. Section 8 has 4 kinds of disqualification that can be covered under it. Let's take a look at what are the 4 kinds of disqualification. Or in fact, 4 subsections. Specific offences under which an MP and MLA can be disqualified, and these offences are, for example, these 4 is what I have laid out as examples. Section 8 subsection 3 is a generic clause in which it states that if any person is convicted for any offence and has been sentenced to serve an imprisonment of minimum 2 years, then he will be disqualified for a period of 6 years from the date of his release. Okay, this is given under section 8 subsection 3. Clear? And then we take a look at section 8 subsection 4 and the final fate of it. Any disqualification made under section 8 can be cancelled if a person who is convicted and is disqualified files an appeal against the order of conviction to a higher court within 3 months of conviction. Clear? And there you have seen the Supreme Court judgment in Lily Thomas versus Union of India. This is a case which has been coming a lot in the recent times because of the current case. In this case, it was held by the Supreme Court that this section is struck down as unconstitutional because the Parliament doesn't have the power to make a law like this, which is in contravention to the provisions of the Representation of People's Act. The Parliament's mandate is not to make it self-defeating. Clear? So this is what we are covering, and the next part what we are covering is the Member of Parliament case in Wayanad, Kerala. So all of this is going very categorically and very structurally to make you understand as to what are the subjects that we are yet to cover and what we have covered and what are the topics that we are going to deal with. Okay. Yeah, so the question about death of a Member of Parliament, sometimes obviously if a Member of Parliament dies, the seat would be automatically vacant. It goes without saying. Obviously, it's too obvious to state. It will be left vacant and the vacancy would be filled by elections, right? So it doesn't need to be necessarily given as a specific clause. Any questions that I can take up now, or you can take a break and come back in an hour and discuss the remaining portions? Are there any questions that I have not noticed or addressed yet? Okay, fine. So we'll take a break for an hour and we'll be back with what we are discussing over here.